Welcome back to the deep dive. Today we're tackling a critical legal problem, one that honestly trips up lawyers, judges, even law students all the time: premises liability.
Hmm.
Specifically, the question is, when can a property owner be held legally responsible for an injury that happens off their property, but was allegedly caused by some hazard on their property?
Right, and this fact pattern, which we're pulling from the case Hale v. Ostrow, it really demands one thing from you if you're analyzing it: just relentless structural precision.
Okay.
The goal really is to avoid that common trap of sort of mushing together the different elements of negligence.
Right. Merging them.
Exactly. So our mission today is to model the required legal analysis. We'll start by laying out the general rule for negligence, then we'll dissect the scope of duty, really focusing hard on foreseeability, and then critically, we'll rigorously separate the two distinct types of causation.
Cause and fact and proximate cause.
That's right. Cause and fact, the but-for test, and proximate cause, which is, the legal limit on liability.
Okay, let's unpack this then, starting right at the foundation. For anyone building this kind of legal analysis, what is that full 5-element framework for establishing a negligence claim?
Okay, the black letter rule requires the plaintiff prove all 5. You need 1, a duty of care owed by the defendant to the plaintiff; 2, a breach of that duty; 3, an actual injury or loss; 4, causation in fact; and 5, proximate cause, sometimes called legal cause.
Got it. 5 elements.
And when we're talking about that first element, duty, courts typically use a balancing test.
Okay.
They balance the foreseeability and the gravity of the potential harm against, well, the feasibility and availability of alternatives to prevent that harm. Burden of prevention, basically.
And foreseeability is key here, you're saying?
It's often paramount, especially as we'll see in urban settings. The scale tips heavily towards foreseeability there.
Okay, let's test that soup of duty with the specific facts of Hale v. Ostrow. This case involves Mrs. Hale walking home in Memphis, busy street. She sees the sidewalk up ahead is completely blocked, just totally impassable because of these thick, overgrown bushes spilling out from the Ostrow's vacant lot.
Mm-hmm. An obstruction.
A major obstruction. So she decides she has to leave the sidewalk, detour around it. But here's the critical part. Before she even reaches the Ostrow's bushes, she trips. She trips over a chunk of crumbled concrete, but it's on the sidewalk in front of the adjoining property, not the Ostrow's land. And she gets severely injured.
And the Ostrow's defense was immediate, right?
Yeah.
Not our problem.
Exactly. She wasn't injured on our property.
So we don't owe her a duty. It's a classic defense in these situations.
That's the hurdle. So let's use our structured analysis. Let's analyze Hale v. Ostrow on duty. First, what are the legally dispositive facts regarding the locations? Hazard versus injury.
Okay, the essential facts are these. The hazard, those overgrown bushes completely blocking the sidewalk, originated on the defendant's property, number 1073. But the injury, the trip and fall on the broken concrete, that happened on the adjoining property's sidewalk, number 1063. And it happened while Ms. Hale was trying to get around the bushes from 1073.
Okay. And what was the core legal issue the court had to resolve regarding the duty element?
The precise legal question was, do property owners owe a duty of care to someone injured off their property if that injury results from a hazardous condition on their property?
So what rule of law did the court apply to answer that? State the full black-letter duty rule again and break down its elements for us.
They used the balancing test we just mentioned. It really has 2 main components, or elements, you need to weigh. First, the foreseeability and gravity of the potential harm. Second, the feasibility and availability of alternatives to prevent the harm. The burden.
Thank you. Okay, now for the court's elemental analysis, step by step. How did the court apply that first element, foreseeability and gravity of potential harm?
The court found this one pretty easily met. They said it was, quote, entirely foreseeable that bushes blocking a public sidewalk would impede pedestrians. That seems obvious, right?
Yeah.
And crucially, it was also foreseeable that a pedestrian forced off the sidewalk might have to detour, maybe into the street, maybe onto uneven ground nearby.
Like the adjoining sidewalk.
Exactly. And that this forced detour could result in injury. The potential harm wasn't some bizarre, unpredictable event.
Understood. Makes sense. Now, what about the second element? Feasibility and availability of alternatives. The burden of prevention.
This is also seen as straightforward. The burden on the Ostrows was found to be minimal. The alternative, well, it was simply trimming or removing the bushes.
Basic property upkeep.
Pretty much.
Right.
And the court didn't just pluck that out of thin air. They pointed to Memphis City ordinances.
Ah, okay.
Okay? Yeah, local laws confirming that property owners are responsible for maintaining adjacent sidewalks and making sure shrubs don't obstruct passage.
Yeah.
So the burden wasn't just low, it was actually legally mandated.
Okay, before we get to the final conclusion on duty, the Ostrows had another argument, right? They invoked that old common law idea about natural conditions.
Yes, they tried that. The argument is basically landowners traditionally weren't liable for harm caused by purely natural features of their land, like, trees falling or runoff. These bushes, they argued, were natural.
So why did the court reject that? Because that distinction used to be pretty solid, didn't it?
It did, but this is where the case gets really interesting, especially for urban property law. The Tennessee Supreme Court explicitly rejected invoking common law immunity for natural conditions in an urban setting.
Why? What was the reasoning?
They basically said the distinction between natural and artificial is irrelevant to the duty analysis in a city today. The focus should remain on foreseeability. The policy rationale was quite powerful. They cited another case, Harvey v. Hansen, pointing out that keeping the old rule would create this anomalous situation. You'd have landowners who improve and maintain their property being held liable.
While the neighbor who lets their property run wild gets a free pass just because the hazard grew naturally.
Exactly. It rewards neglect in a setting where properties are close together and neglect inevitably impacts the public way. In a dense city, that old rule just doesn't work anymore. The court chose foreseeability over formalism.
Okay, so after analyzing foreseeability, the minimal burden, and tossing out the natural condition defense in this context, what was the court's final conclusion on the duty element? Did the Ostrows owe Mrs. Hale a duty?
Yes, they did. The court concluded that the Ostrows owed Mrs. Hale a duty of care to make sure the sidewalk wasn't blocked by their overgrown bushes, ensuring it was passable, even though her injury ultimately happened on the neighboring property.
Okay, let's try to really cement that policy shift away from the natural-artificial distinction. Imagine a slightly different scenario. Landowner in a dense city neglects a big old tree on their lot. A huge, clearly rotting limb, a classic natural condition, hangs precariously over the public sidewalk. One day, it snaps. It doesn't hit anyone on the sidewalk, but it crashes down onto the street, maybe narrowly misses a bus.
Okay.
But now, the fallen limb, the debris, it forces pedestrians who would use the sidewalk to walk out into heavy traffic to get around it. If one of those pedestrians gets hit by a car while detouring in the street, how does Hale's rejection of the natural-artificial distinction apply? Would the landowner owe a duty?
Based on Hale, the duty would almost certainly exist there too. The analysis shifts completely away from whether the limb was natural.
Right.
The focus is squarely on the foreseeability of the harm, pedestrians being forced into traffic and potentially getting hit, which is caused by the impediment originating from the defendant's property, in this case, the fallen limb blocking the way.
So the source doesn't matter, only the foreseeable consequence of the obstruction.
In an urban setting, yes. That's the policy Hale strongly reinforces. Landowners can't just let their property, whether natural or not, create foreseeable hazards for people using public ways right next door. Neglect has consequences when you're packed together in a city.
Okay, so duty is established, check mark. But as you said, that's only half the battle. The other big trap here, and maybe in all of torts, is causation. You stress there are two distinct types. Why is keeping them separate so vital, and why do lawyers and apparently even courts sometimes confuse them?
They are absolutely distinct elements, host speaker, and yeah, confusing them is exactly why the lower appellate court here in Hale got reversed. You have cause, in fact, which is purely about the factual link. Did the defendant's action actually contribute to the harm? We test this with the but-for test. And then you have proximate cause, which is a policy judgment. It's about setting a limit on liability, asking if the harm was a reasonably foreseeable type of consequence, or if the chain of events is just too attenuated or bizarre.
And you need both.
You absolutely must prove both separately. Failure to keep them distinct leads to muddled analysis and, well, incorrect outcomes, like the initial summary judgment here.
Okay, let's go back to the Hale facts then. The Court of Appeals below the Supreme Court, they actually found the bushes were not a proximate cause. Their reasoning was that Mrs. Hale fell on the concrete before she even reached the bushes. They essentially said, look, she would have tripped on that broken concrete anyway.
Right. They jumped straight to a conclusion based on the sequence.
So, analyzing causation in Hale now, using our structured approach, what was the core legal issue regarding causation that this lower court mistake created for the Supreme Court?
The issue is whether there was a genuine issue of material fact, meaning something a jury needs to decide as to whether the Ostrow's overgrown bushes were both a cause in fact and a proximate cause of Mrs. Hale's injury. The lower court improperly treated a factual question as a matter of law.
Okay, let's isolate cause and fact first. What's the rule used to test that? The but-for test. What's its core element?
The rule is indeed the but-for test. The key element, simply put, is proving that the defendant's conduct was a necessary antecedent of the harm. Ask. But for the defendant's act or failure to act, like here with the untrimmed bushes, would the plaintiff's injury have occurred?
Okay. Now for the elemental analysis of cause and fact, but-for. How did the Supreme Court apply that but-for test to the facts of Mrs. Hale's detour and fall?
The court looked closely at Mrs. Hale's deposition testimony. She stated the bushes had completely blocked the sidewalk.
Right, force the detour.
Exactly. That obstruction compelled her to leave the sidewalk and move towards the street area where the broken concrete happened to be. So the court reasoned. But for the bushes blocking her path, she wouldn't have been walking in that specific spot where the other hazard existed.
So even though the bushes didn't trip her?
They put her in the position to be tripped. Because reasonable people could disagree about whether the bushes were a necessary step in that chain of events, maybe she could have squeezed by, maybe not, the court decided. But for causation was a genuine issue of material fact. It had to go to the jury.
Understood. It's a factual chain of events question. Okay, now moving to the second type, the policy check. Proximate cause. What's the rule for proximate cause again?
Proximate cause, or legal cause, is about whether the connection between the defendant's breach and the plaintiff's injury is strong enough and foreseeable enough to justify imposing liability as a matter of policy. It asks, was the injury a reasonably foreseeable result of the defendant's conduct? It's about drawing a line somewhere.
And how did the Supreme Court apply the proximate cause analysis here, especially in relation to the lower court's mistake?
The Supreme Court pointed out that the Court of Appeals had fundamentally confused the two types of causation. When the lower court said the injury would have happened anyway because she tripped before reaching the bushes.
That sounds like the but-for test.
Exactly. That is the but-for inquiry, would the injury have happened but for the defendant's conduct. The lower court incorrectly labeled its but-for conclusion as a proximate cause conclusion. Since the Supreme Court had already determined that but-for causation was a jury question, because reasonable minds could differ on whether the bushes forced her path, the question of proximate cause, whether tripping on something while detouring was a reasonably foreseeable consequence of blocking the sidewalk, also had to be a question for the jury.
So establishing the but-for question was enough to send proximate cause to the jury, too.
In this case, yes. Because the type of harm, falling while forced to navigate around an obstruction, is generally considered a foreseeable consequence of creating such an obstruction. Determining whether the specific way it happened here, tripping on adjacent property, was within that scope of foreseeable risk was deemed a factual determination for the jury, not something the judge could decide as a matter of law based on these facts.
And so wrapping up the analysis of Hale, what was the final conclusion of the Tennessee Supreme Court?
The court reversed the summary judgment that had been granted to the Ostrows. They concluded there were genuine issues of material fact regarding both cause in fact and proximate cause. The case was remanded, sent back down for a full trial where a jury could decide those factual questions. Okay, so pulling this all together, especially for listeners trying to structure their own analysis, maybe for an exam, or even just thinking through a problem, here's a diagnostic checklist based on how Hale v. Ostrow approached this specific scenario, Prezis's liability involving off-site injuries.
Excellent. Let's distill the strategy.
All right, 4 steps. First, identify the defendant's conduct.
Yeah.
What exactly was the act, or more likely, the omission originating on the defendant's property that created the alleged hazard? Pinpoint it. Was it the untrimmed bushes, a crumbling wall, maybe poor drainage?
Step 1. What did the defendant do or not do on their land?
Precisely. Second, test duty. Apply that balancing test, foreseeability and gravity versus burden. And critically, when you're thinking about foreseeability, ask specifically, was it foreseeable that this conduct would force a third party, like a pedestrian, to change their ordinary path or how they use public space? And remember, Hale's big move in urban areas. Ignore that old natural versus artificial condition distinction. Focus on foreseeability.
Okay, duty test, focusing on foreseeable detour. Got it. What's third?
Third, test cause, in fact. Apply the but-for test rigorously. Ask. But for the defendant's specific conduct, the obstruction, the hazard, would the plaintiff have been at the exact location of the injury in that specific way at that moment? Remember, the defendant's conduct only needs to be a cause, not the sole cause.
Right, before, was it a necessary link in the chain?
Yes. And fourth, test proximate cause. This is the policy check. Assessing the limit of legal liability. Ask, is the resulting injury, even if it occurred off-property or in a slightly unusual way, a reasonably foreseeable consequence of forcing the plaintiff into that situation, like a detour? And a key practical tip from Hale. If the but-for analysis involves a complex chain of events or is debatable, proximate cause is almost certainly going to be a question for the jury, not for summary judgment.
That's a very clear framework. Identify the conduct, test duty focusing on foreseeable detour, test but for causation, then test proximate cause foreseeability, keeping in mind that factual complexity usually means it's a jury issue.
That's the structure Hale models.
This deep dive really shows how the Hale court didn't just, affirm a duty in one specific case. It seems like it redefined the urban landscape as this deeply interconnected environment, right?
It certainly leans that way.
By refusing to recognize that difference between natural and man-made conditions for negligence in a city, they arguably expanded the whole idea of foreseeable harm. So here's a final thought for you to consider. If we really follow this Hale logic, that maybe an urban landowner's property line isn't quite the hard barrier it used to be for liability purposes, could this principle extend further? What about other traditional tort immunities or limited duties that rely on property lines, like maybe rules about snow and ice removal from public sidewalks, or even duties regarding lighting in dense areas? Could those also start to erode based on the sheer foreseeability of harm in our packed, interconnected urban world? What new duties might arise next? Something to mull over. Thanks for taking this deep dive with us.